My client was stubborn, really stubborn. The defense made a sizable offer to settle the case. I recommended that offer. My client said no. Find out what happened. Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now we're getting close to trial, and the defense comes to us and makes a sizable settlement offer. After having lengthy discussions with my client, I actually recommend that offer to the client. I tell him, listen, it's highly likely that a jury is going to come back and give you the same amount of compensation as the defense is now offering. And even if they do give you a tremendous amount of money, what will happen is the defense will go ahead and appeal that. You'll wind up taking 2 years out of your life to get a decision on the appeal, and it means that we could probably come back 2 years from now, retry the case, or possibly get the case thrown out. So what do you want to do? He said, I am not taking this offer. My case is worth much more. So what happened? Well, we had to go to trial. And I had to call the defense attorney and let him know that I could not accept the settlement offer, even though I truly believed that it was an appropriate offer. So you know what happened? We wind up going to trial. During jury selection, I spoke to the defense attorney, and he said to me, listen, I'm sorry your client didn't accept the offer, but my client and I are of the belief that because you did not accept our offer, we are now withdrawing our offer. So that sizable settlement offer, which was on the table, now has been removed, has been revoked. So now I had to get back on the phone with my client and let him know the defense has revoked and taken away that settlement offer. So now it's as if they've offered zero. And we had no choice but to go to trial and take a verdict. Ultimately, what did the jury say? The jury disagreed with my client. They did not believe he was entitled to be compensated for his injuries. So why do I share this great information with you? I share it with you because when you go to trial, you never, ever know what's going to ultimately happen. You don't know what the jury is going to do. And even though you may think you have the best case in the world, when a sizable settlement offer comes in, and now we have a lengthy discussion about the risks and benefits of accepting the settlement offer, and I make a recommendation to you and you make a decision, you've got to live with that decision regardless of what happens. The reality is, the only way we can get compensation for my client's injuries is if we can show that we are more likely right than wrong, that the person you have sued is careless or was careless and is responsible for your injuries. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on in the litigation process here in the state of New York in cases involving medical malpractice, involving accident matters, and involving wrongful death. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, again, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.